Stephen, thank you, Aaron, so much.
Thanks for having
us. Take care. All righty. Now over to John.
Trial Tuesday, once again, everyone, adoptions can sometimes be tricky legally, of course, and David Aylor, the Duke of Discovery, the superhero of subpoenas, joins us right now to talk about one low country adoption case that's made it all the way up to the Supreme Court of the United States. Counselor, welcome back to the show. Of course, we're talking about the Capobiancos of James Island, their fight to get their little girl back. You can see her right there, baby Veronica. Let's take this thing back to the beginning, because you're saying there's some legal issues with the father before that child, Veronica, was even born.
Right. Essentially what happened here was there was obviously baby Veronica was not in this world yet, but her mother was letting the father know that she was having the child, and she did that through text messages. At least that's what the court documents allege. And those text messages were acknowledged by the father. Essentially, she had the baby on her own without the support of the father, and then ultimately gave that child up for adoption sometime thereafter. And then once the father found out about that, he protested. And so the key issue is, should he have been notified? And since he was not notified, that's where the Indian Child Welfare Act comes into play.
So he went to the courts and said, you know what, that is my child. I'd like her back. I'm going to play this card, if you will, the Indian Child Welfare Act, which protects Native American families and was brought to the courts and enacted into law to keep those families together. So they took baby Veronica away from the Capobiancos here on James Island and brought her to the father. Now the Capobiancos are challenging, and this thing has gone through state's courts and now is in Washington.
Right. It's been appealed all the way up to the Supreme Court. And for those that don't know, the fact that the Supreme Court actually decided to hear it is amazing in and of itself. They have thousands of cases that get petitions each year, and they usually choose, not even a full 100 or so. So the fact that it's going in front of them is interesting to the degree that what they're going to be looking at. One, the Child Welfare Act in and of itself, but also what specifically happened in this case. From the adopted parent standpoint, they feel like that the father more or less denied the child and did not support the child, and therefore really can't be considered a parent, can't be considered a father, and should not have been, identified and had to have been, basically given permission or his blessing for the child to be adopted.
We're looking at right now a lot of the conversation is around the language of what is a parent under the Indian Child Welfare Act. How much do you think that comes into play in this case?
I think it's huge because obviously from the adoptive parent standpoint, they feel like that this individual did not prove to be a parent. Therefore, he should not have those parental rights. If it's shown that he is a parent, then it's clear law from the Federal Indian Child Welfare Act that he, in fact, should be notified prior to any type of adoption. And that's why he has the child. He's had the child since January of 2011, and that's based off the court decisions here in in South Carolina, rather. But ultimately, if the adopted parents can prove that, in fact, he shouldn't be considered a parent, as you mentioned, under the law, then, the child would then go back to them.
We spoke with former State Attorney General Charlie Konnen, and he said that it really is amazing, as you reiterated, that the Supreme Court would even take this case up. But he says it's a good sign that the Supreme Court would take the case, yet it's, in his legal opinion, that baby Veronica will probably stay with her father. What is your opinion?
Well, you got to look at the history of the case, and at this point, going all the way up through the state courts, that's where it's been. For that to be turned over, there's going to be something that really hasn't been really looked at, and that's highly unlikely at this point.
And this child has had such a traumatic upbringing already, going from the Capobiancos here on James Island to her father out west, and then going through this legal battle. It's got to be harder on the child, I would assume, for her to uproot her life once again and come back here. Does a judge, does a Supreme Court justice take that into account? Absolutely.
They look at the best well-being of the child. What's in the best interest of the child? At this point, you have a child that was somewhere around 2 years old when it left the adopted parents and has now been over there for about 2.5 years almost with his father and his wife. So that will come into play. Those formative years are so important. So ultimately, though, they have to look at the law and determine whether or not he was a parent. And if he was a parent, then he should have the right to have been notified prior to the adoption.
David Aylor, quickly, they hear oral arguments today. The decision is not until June, I believe. What is the Supreme Court doing in between here and then?
Well, ultimately, what they hear today is somewhat ceremonial. There's a lot of research that they've already done, and what they're going to hear is questions that will be posed to both sides from points that they feel like that they've researched and haven't been shown in either of the arguments. After that, then you're going to see more research and things that will be done in the background, and then ultimately that decision written and come out here in the next couple months.
All right, ABC News 4 is following. Eric Ian is in Washington with coverage starting tonight. Attorney David Aylor, thank you for your time as always.
Thanks for having me.
Appreciate it. We're back with more Low Country Live after this.